Necessity may be the mother of invention, but technology is its midwife. The Supreme Court of India's use of video conferencing to take up urgent matters while regular hearings stand suspended in all courts during the lockdown period has the potential to accelerate the pace at which technology could be adopted by the judiciary at all levels. Good evening, ladies and gentlemen. Law Essentials welcomes you to the 20th edition of the webinar on IPR and Emerging Technology. Law Essentials is a student-run initiative by a group of inquisitive law students having a penumbral idea about the application of law in day-to-day life. I am Mohammed Farhan, founder at Law Essentials, publisher at Law Essentials Journal, and a student at St. Joseph's College of Law, Bengaluru. Now let me introduce the speaker for today's session, Advocate Sai Sushanth. He's a cyber law expert and techno-legal consultant, and he's also the CEO at Sushanth IT Law Associates. He's an awardee of PW Legal Under 40 List of Achievers. We congratulate you from the entire team of Law Essentials for your achievements, sir. We are privileged to have you as a speaker for the third time in our sessions. We are extremely honored for this opportunity. I would request you to start off with the presentation, sir.
Thank you. Thank you so much. A very good evening to all the participants of this session on IPR and emerging technologies. I must say I'm really privileged and honored to be part of this wonderful talk, which is by Law Essentials. Once again, thank them for a wonderful opportunity. I think they're coming up with distinctive topics in various fields of legal jurisprudence. And I believe that conferences, webinars like this would play a very important key landscape in coming up with different legal parameters and also to come up with different ideas to build new legal jurisprudence surrounding technology and law. So thank you so much once again. And I must once again congratulate them for their wonderful the way they're progressing. I've been part of their organization and then being constantly giving talks. And I must really say that the moment I'm coming up on a talk, and I must say that there is a lot of enthusiasm in coming up with new ideas and also trying to make this as a very good platform for law students and also connecting them with different legal professionals across the country. Once again, congratulate them for their journal as also for their new center of intellectual property. I'm wishing them a very good endeavor and success in all their fields. Thank you so much. And specifically Farhan for this thought leadership of coming up with this distinctive idea of coming up with a journal as also a center on intellectual property. Thank you so much. And to start off with today's session, I think it's a very interesting ball game because technology is something that's rapidly increasing. And the moment you're looking at technology evolution, I think I'm myself surprised because today there is almost nothing that is not digital, thanks to COVID-19, because it's just pushed each one of us on the digital environment. And more specifically, once we start using this cutting edge technologies, I think there is going to be enormous amount of intellectual property that's going to get created and also that's going to be shared across these emerging technologies. So I just wanted to just highlight some of the emerging technologies and also talk about the intellectual property rights and also legal challenges surrounding these technologies. So that's the whole objective behind my session. So let's get on to the session, please. Could we go to the next slide? Yeah, so first, let me just give you a small introduction about intellectual property. See, intellectual property is something that can be created anywhere and everywhere because it's something that's happening with the creation of mind. So wherever you're trying to come up, whatever be the nature of profession and job, surely intellectual property is going to be something that's clearly going to be occupying a very major role in terms of your thinking and thought process. So that being so, it is something that you can feel, but you cannot touch it. It's intangible. And just like you have physical properties, I think more specifically, it's going to be intellectual property that's going to be creating huge amount of what shall I say, opportunities, as also some kind of legalities surrounding intellectual properties would have to be kept in mind when you're actually trying to create any kind of thought or an idea. So, just to give you some broad perspective on intellectual property in India, we have different kinds of forms of intellectual property: patents, copyrights, trademarks, trade secrets, uh, designs, semiconductor layouts are some of the intellectual property forms that are presently very popular in India. So, you can protect your intellectual property by way of any of these, and also by all of these for that matter. So trademarks, copyrights, patent, trade secrets, designs, semiconductor layouts are some things that are very popular. Of course, we do have the geographical indicators, we do have the plant breeder rights and things like that. But when I talk of technology, I think these are some things that clearly will have to be kept in mind while you're trying to protect your intellectual properties. So today I thought I will just take you through some of the emerging technologies like artificial intelligence, blockchain, cryptocurrency, crypto assets, and also in IoT, 3D printing. So these are some things that I thought I should take you through because given the kind of nature of these technologies being disruptive, I believe that intellectual property is going to play a very, very important role in these kinds of technologies. So not just that, this could be one of the thought process that young lawyers can look at more specifically because there are going to be immense amount of legal career opportunities when I talk of intellectual property in terms of emerging technology. Why? The reason being that these emerging technologies would be requiring a distinctive application of a law and technology, which would be very effectively addressed in case you have some kind of a basic understanding on how technology works and also how to actually blend your legal knowledge with the technology. So this is going to be a good career path. So I thought I should also put forth these areas because these are some of the disruptive technologies that the present technology market is actually witnessing. Let's go to the next slide, please. When I talk of AI, primarily I just want to tell you about AI. Fundamentally, artificial intelligence works on data and data sets. So the more and more data is fed, the more and more accurate the AI system becomes. I believe that each one of us who are today making use of Google are making use of artificial intelligence. Why? The moment you have predictive tests, you have some kinds of predictive analysis with the help of Google. For example, if you were to search about one particular item, then that particular item gets reflected automatically in Google, and you'll have a number of what do you say display parameters that will be put up, so therefore enabling you to choose among the best of the best with the help of artificial intelligence. Not just that, each one of us who are trying to make use of Google for the purpose of doing our Google search and doing research on any one particular aspect, AI is playing a very increasingly important role in terms of that. Now the question that comes into picture is, yes, AI as a technology is fantastic. Okay, this it's going to be completely a game changing technology, and given the kind of applicability in all sectors of verticals, I think AI will play a very, very important role in terms of redefining and re-innovating the business, no matter whatever be the business ideas. So that being so, AI will increasingly bring forward a huge amount of intellectual property perspectives. How? Like I told you, AI primarily runs on data and data sets. And the first IP issue that probably comes onto the table is who owns this particular intellectual property that's been fed into the artificial intelligence system. Number one. Number two, when you start making use of artificial intelligence, there are two distinctive things that you'll have to keep in mind. Number one, the machine learning. Number two, we have something called NLP, natural language processing. I think when these two are made use of in conjunction with AI, there's going to be huge amount of a different paradigm altogether. Why? Because it's no longer that the system is only understanding your data, but apart from understanding your data, the system is also trying to interpret the data that's been fed into. So the interpreted version versus the original version, I think there's going to be huge amount of intellectual property that's going to be created among this particular transaction. So let's say that let's take the example of a particular a tool. Let's take, for example, since we are all lawyers and we are all from the legal community, let me give you a small example. Let's say that there is a particular AI tool which tries to help you in your legal research. So let's say that you're researching on one particular area, that is intellectual property rights. So you feed in a lot of information relating to AI and IPR onto the AI system. Now you are wanting to get a specific query addressed by the system. So what do? You go ahead and you try to seek the different interpretations of whatever is being fed into the system through the AI system. So what happens in this case? You feed in input, and as a result, the input is analyzed by the AI system, and it comes up with a totally different output altogether. Now, in this kind of a scenario, the question that all of us will have to answer is, who owns this intellectual property? Would it be me? Will it be the system? Or will it be the respective coder who has actually coded this particular system? Or will it be, if I've taken this AI system on a license basis, is it the entity that's actually given me a license owning the data? I think these are just some questions that will pop up in your minds when you talk about artificial intelligence and intellectual property. So it's not just that. Now, when I look at the IPR, there are going to be immense amount of IP related infringements. Now, the first question is, can AI be a creator? Second, can AI be a contributor for infringement? Number three, can AI be sued for any kinds of breaches or infringements? So these are three questions that will have to be constantly understood when you talk about AI and intellectual property. So we do not have any clarity when you look at the present laws, because there is no clarity with regard to the legal status of AI. Now, how will you treat the artificial intelligence entity? Is it an agent? Is it a corporate entity? Is it an employee? Is it acting as your representative? How are you going to legally give status to this AI system? That's one critical aspect that we'll have to look at. Not just that, suppose, let's take the example of copyright. Now, copyright can protect few areas, of which literary works can also be one of the major areas. Now, let's take, for example, that whatever output that has been generated from an AI system is very unique. You wish to actually take copyright protection for that particular data. Now, can you take copyright with respect to the output which is generated from an AI system? That's going to be an interesting question. Not just that, in case you want to infringe, you want to adjudicate any kind of IP infringement. For example, let's say your AI system has actually infringed the copyright of some ex author. So, how are you going to handle this kind of a scenario? What's the legal position? Can you sue it, or can you sue the AI system as a whole, or can you sue the person who has actually tried to feed in the data, or can you try to sue the person who has actually coded that, or can you try to sue the person who has actually provided that AI system to you? That's $1 million question. I think these questions can be answered in when you talk about hypothetical example. I think we can to an extent talk about the IP related infringement in these cases. Let's take hypothetically the example of how IP infringements can be evaluated when it talk about any breach or any kinds of infringement done by an AI system. Number one, let's say that in case the data which has been fed into the AI system, that particular person is very well aware that this particular material is not his original, is not information in public domain, but it's copyrighted information. Then, despite knowing the fact that it's copyrighted information, if he's actually trying to use that particular information, it's okay if he's using it for his own personal use, so long as you're able to have limited percentage, limited audience, you're doing it in interest of public, you're doing it for a particular benefit, okay, you can claim the exemption of fair use. There's no issue. But if I were to file an intellectual property based on the output of the data, then that becomes a different ballgame altogether. So thereby, I'm trying to create an intellectual property on which is based on the intellectual property of someone else. So how far and how real will that be supported by law? That's a big question that we'll have to look at. And secondly, now let's say that if this particular AI system was developed and the system is able to identify based on certain parameters that this is copyrighted material and this is not copyrighted material, maybe looking at some basic parameters, maybe looking at the copyright symbol and things like that, then I think to a certain extent, these kinds of problems may be reduced. Of course, what we're talking is very simplistic concept, but actuals be far more implicated and complicated. But just to give you a broad spectrum, these are going to be some areas I thought would be a very importantly would have to be looked into from an IPR perspective. Could we go to the next slide, please? Yes. So when I was just trying to talk to you about this, look at this. The US Patent Office had come up with a recent quote that the AI cannot be made a legal inventor. So what does it mean? It means that if in case your AI systems come up with some kind of innovations, then the AI system itself cannot become an legal innovator under the patent law, because usually patents are granted only to human beings or natural persons. That's one of the claim that USPTO has. Okay, let's go to the next slide. Now, however, this guy is actually trying to sue the patent office for deciding that AI can't invent things. Wow. Now the decision is awaited. We're in the phase of transformation and we are in the stage of voyage. So I believe that once this decision comes up, I believe this is going to set forth a certain legal parameters when you talk about whether protecting any kinds of inventions out of AI systems is legally possible or not. I think some direction, some parameter would be laid down by this particular case. Next slide, please. Now, in general, when I talk of how we can protect artificial intelligence with regard to AI, how we can protect the IP with regard to AI, one good form is if you're looking at hardware, then the AI algorithms could be protected. You couldn't have copyright. The process and working, that is device and system, you could use, you could go and file a patent. Number three, if you're looking at algorithm and codes, I think copyright would be some of them, one of the good areas that you can look at. Of course, something more than AI, that is code and algorithm, that's also something you can look at. So primarily, these three are the parameters that you can look at if you want to protect your AI-based invention. So hardware, algorithms, device and systems, process and working, and code and algorithm. These are some parts of AI that could be prone to IPR protection. Next slide, please. Now, specifically, when I look at the landscape of Indian patent law, there's a small amount of challenge. When you look at the requirement of a patent under the patent law is very clear in stating that the patent would be the first, would be provided to the first inventor of the invention. Okay, agreed. Let's move on. The patentee who's filing the patent application would have to be a natural person in order to acquire ownership of patent on that particular product. Okay, that's also agreeable. Now, one of the trickiest part is here. Now, the patentees also can be sometimes non-natural persons, that is government entities or government organizations. In that kind of a scenario, since we also have this landscape of non-person entities, can AI machines which are non-person entities, also be granted patents? That's a brilliant dollar question. But I can tell you, just going by this definition, I think there's still uh, enough room for interpretation that uh, the AI system, if it comes up with any kinds of inventions, I think looking at this, it could probably leave some room for discussion that AI systems innovations, whatever innovations are coming out of this AI systems, are capable of getting patented. Well, that's something that is ambiguous, but purely going by this analysis, I think it still has some kind of a room for interpretation. Next slide. Now, one of the areas that are going to that the AI will bring into the table is when I talk about IPR and AI, there are some going to be distinctive legal challenges. Number one, with regard to ownership. Now, who will own this particular IP? Now, let's say that looking at the definition, what we discussed, for example, let's say that AI system has been granted a patent. Now, who will own this particular AI system? Is it a legal entity on its own, or is it the a particular person or entity who's actually making use of the AI system, or is it the manufacturer of the AI system, or if it is given as a service or a license, then is it the entity who's actually providing license? That's another questionable area that we have to definitely be aware and cognizant of. Next slide, please. Wait, one second. One second. So apart from that, we would also have to understand when you actually provide ownership to AI entities, going by the definition, somewhere down the line, we'll also have to provide some kind of responsibility. Okay, that's fine. But can AI systems have the capacity to sue people for infringements? Because as an IP owner, you would actually have the opportunity to actually sue the infringers or people who are actually trying to violate your intellectual property. That's going to be an interesting question altogether. Now, one more area that's going to be bringing in huge amount of discussion is, can an AI system uh, actually try to license its intellectual property? How will the licensing concept be taken up? That's also one more interesting area that the IP and AI will bring on the table. The reason being, if an AI system becomes the owner of intellectual property, then how will it be able to, as an IP owner, it will have all the legal rights in order to license the systems, license whatever the intellectual property it has for a certain consideration. But how will this licensing concept be handled? I think that's something that we'll all have to quickly understand and look at. So I think these are some of the areas that I believe that are going to be that have to be looked into before we actually try to come up with any kinds of legal jurisprudence surrounding AI and IPR. I think this is getting more and more predominant, specifically because uh, if this AI can be actually given some kind of legal recognition, this kind of issues can actually be trying to address to a certain extent. Once you tie up with the idea of providing some kind of legal recognition to AI systems, and then try to talk about IPR protection, it will make more sense, because we will be able to exactly identify whether AI system is a separate legal entity, or it's an agent, or it's a representative, or it's some kind of a what do you say? Right? It's an employee of this particular organization who's actually leveraging the AI. So that's going to be very interesting. And apart from that, there's one more question also that will come into the discussion. In case, can I say that since I've developed my AI system, whatever output is generated out of the AI system becomes my intellectual property, because I am the person who has actually fed the data. I am the person who has actually made use of that. That's a very interesting challenge. Now, how will you actually try to come up with concepts like work for hire and things like that? Because work for hire, when you look at the copyright law, it's very clear in stating that the entity or the person who's developing or who's actually trying to create some content becomes, or create anything, becomes the first owner of copyright. That being so, when an AI system creates some kind of content or some kinds of material, who owns the intellectual property? if I don't have any understanding regarding the legal status of the AI system, can I say that because I am the company, or I'm an individual who has actually leveraged that AI system for generating this data, will I be owning that particular intellectual property? How am I to talk about that? That's going to be a very interesting domain when I talk of AI and work for hire. Second, next slide, please. Yes. So when you look at this slide, you can very clearly understand that apart from just creating content, AI systems are also capable of creating artistic works. So now copyright is something that can be coming into the picture here, because the reason is that copyright protects artistic works and also sound recordings. So if a AI system is actually creating an artistic work, who owns the intellectual property? Is it the system because it's programmed to do so? Or is it the coder who has actually inserted the code? Or is it the particular company who has actually directed this particular, fed the instructions for drawing this particular, fed the data of this particular individual? Who's going to own the intellectual property? Now, can the AI system itself be responsible for it? No, likewise, when you talk about sound recordings, if an AI system is used to create music and sound, who owns that particular sound? That's also one area. Now, apart from ownership, who's going to be responsible in case there's an infringement? Now, that's also very interesting question that we'll have to understand. Now, all along, we've been talking about one side of the coin, which is talking about ownership issues. Now, let's talk about the infringement issues. Let's say that the AI system had actually been breached or actually violated or infringed upon the intellectual property rights. Then, who would be the person who would actually be responsible? Is it the AI system? Is it the coder? Is it the manufacturer? Or is it the entity or person using that particular system? Who is liable for infringement? Then again, that is going to be a very interesting one, because again we have contributory infringement, we have vicarious infringement, and things like that. So these are also going to be something that we'll all have to understand. Not just that, suppose, let's say for example that an AI system infringes upon it. The other day I was actually trying to address the law enforcement officials on IPR infringements in cyberspace. So talking about the same issue, now the police have got the power to actually try to search and seize all the properties which are infringing. Now, let's say that the AI has created some kinds of algorithms. Now, how can the police seize the algorithms? That's also going to be one more interesting area that we'll all have to understand. Now, who will be a party here? That's going to be an interesting challenge. And apart from that, in case the particular person who's actually trying to very well know that it's a copyrighted material, then I believe that abatement can also be put against this particular individual who's actually with having significant knowledge that this is a copyright material. Despite knowing it, he has actually made use of the AI system to actually create copies of it, or do create some kind of artistic works like this. That's going to be a very interesting gamut. Now, infringements, apart from ownership, would also be very interesting when I talk of intellectual property and also artificial intelligence. I hope you got some understanding on the artificial intelligence and IPR. So this is just to give you a basic overview on the emerging technology of AI and intellectual property. Next slide, please. Now let's go a bit more further. Let's go to blockchain. Now this famous uh, company which has this beautiful footwear has come up with a patent for its blockchain-based sneakers called CryptoKicks. I think this is a wonderful option that the company has actually tried to come up with, because ultimately they filed a patent for its blockchain compatible sneakers, which where this particular blockchain system was actually talking about the ownership, digital ownership of this particular footwear of an individual. So when you buy a pair of this particular crypto kicks, you will receive a digital asset which is attached to a unique identifier of that particular shoe, and as a result there is a digital asset that is created, and it is actually effectively tied up with the production house. So therefore, the production house will have a list and track of who is the actual owner of this particular piece of footwear. So when you buy it, you'll receive a digital representation that will be linked to the consumer, and also you'll be provided with a cryptographic token. So this is a digital shoe and a cryptographic token, which together represent this called crypto kick altogether. So when you have this digital ownership, it's fantastic. Now, original patent application has been filed, and however, the USPTO is now. I believe it's we can expect some kinds of a wild west happening in this kind of a scenario. So all I wish to tell you is that, see, there are a lot of different inventions based on blockchain that are emerging altogether. So this is one such example. Next slide. So first, let me just take you in a very nutshell manner with regard to blockchain. So blockchain, in the simplest form, I can tell you that each and every participant of this particular session would be able to see the screen. Let's say that Law Essentials is the network, because it is the organizer who's actually organized this session today. So let's think, for example, that the organizer is the network, and each and every member of this session today, including myself, we are all blocks. And how are we connected? We are connected through this particular either YouTube or this particular tool that we are all presently in. So we are all connected. So let's think, we are all blocks. We are all connected to the organizer, which is a peer-to-peer network. Now, everybody who's actually a participant to this session would be able to see the screen. So what does this mean? Is this available to outsiders? No. Unless you are accessing this, you will not be able to actually share or get the screen as such. So let's say that this is the information that I'm putting on the block. So since I'm also a part of the block, I'm inserting my data, which is nothing but the PPT. So this is visible to all the members who are there in the present session. So likewise, each and every, once you create a data and you put the data on the block, each and every person in the block would be actually would have access to this particular data. So we are all connected, and there we are all connected to blocks. Here we are all connected to the organizer. So the peer-to-peer network becomes your organizer here. Now, in case your organizer is giving you some kinds of certificates, so imagine that these are nothing but your what do you say, cryptos. Take the certificates to be crypto coins. So because certificates are unique. So that's the relationship between cryptocurrency and blockchain. So in a nutshell, I believe you got some understanding on blockchain. It's totally the concept of a trusted network. It removes the concept of intermediary and middleman altogether, and thereby, same like this, where we don't have any third parties here. We don't have any event managers, or we don't have any kind of a third party organizers for this webinar. So directly, it is the organizer himself. So therefore, in the same way, it's a trusted network altogether. So if you are actually trying to make use of Zoom or any other video conferencing tool, I believe you also have passwords. So they are the authentication mechanisms. So in blockchain technology, we call that as hash. So what happens? The organizer first creates a hash, that's a meeting ID, and then he passes. Let's take the meeting ID to be the hash, original hash. Now, each and every person may be having a password. So the password can be the hash. So original hash versus the created hash. So when you have a blockchain, the first block actually has the original hash value, and each and every block has a unique. Just like all of us have names, we have unique names. So you have unique hash values. So if I were to say that Law Essentials is gives you participant IDs, for example, then your ID becomes the hash, and your name becomes something that you already have. So each and every block in the chain will have two things: the value, hash value created on its own, and the previous hash of the previous block. So that's how the chronological order is maintained. So likewise, when I talk about blockchain and intellectual property, there are going to be immense amount of intellectual property related issues on a blockchain. For example, once I'm publishing this information on the block, now take the example of my PPT. Now my PPT is visible to all the people who are viewing this particular session. So what happens here? There is an intellectual property created. Why? I am making use of, I have generated data, I have generated my PPT, and I have generated my content. So therefore IP is created. So once this IP gets published on the block, therefore it is definitely capable of intellectual property protection. I can protect this. But while again there is an ownership issue. Why? Because I may not be directly playing this particular PPT. I might have shared this with an organizer. An organizer may be sharing this with you. So likewise, who owns this particular information in the block? Is it going to be me, or is it going to be the trusted network? That is in our case, is it going to be me, or is it going to be the organizer? That's going to be one interesting question. Now, the second interesting question that would have to be looked into is, now let's say that we are all making use of different forums. Let's say that you're hosted this on YouTube. For example, if YouTube has a policy that whatever content you're displaying on YouTube becomes information in public domain, then what happens? I will not be able to protect my intellectual property. That is this slides. Why? Because when I talk about the nature of YouTube, it itself is trying to say that no, when you publish something on my domain, it's something in public domain. Something in public domain cannot be legally protected. So let's say, for example, that I'm making use of a blockchain service provider like YouTube. Who owns the content? Is it YouTube, or is it the organizer, or is it me? So just I'm just trying to give you a simplistic understanding so that we can follow things in a better manner. So that's also going to be one more interesting area, because sometimes we may not be able to create a blockchain. We may take blockchain as a service from third party, and that third party might actually make use of one more third party for the purpose of developing. So who owns this particular blockchain is a great dispute. And apart from that, when you are taking blockchain as a service, for example, who owns the data? That's going to be $1 million question. Now, when you look at this particular data, because this data in the block is, how will you authenticate it? Is it the creator of the data? Is it the peer-to-peer network, or is it the third party? That's one thing that you have to look at. And many a time, what happens is all this data. It's not just one block, but all these are related. So when you have all of these related information as a whole, who owns this data collectively? Now, I told you about individually. Now, collectively, who owns this data? That's a very big question that we'll have to understand. And because copyright can also be taken on data sets and databases. Now, let's say that the database is maintained. For example, this webinar. Now, all the data relating to this webinar is maintained by Law Essentials. Now, Law Essentials can essentially file a copyright for all the data that they have, participants' names, details, these things like that. Now, if they file the database, I mean, copyright on their database, who owns it? Because this is not their own database. So that's again a debatable question, because they are making use of third-party information also. Like my data is also there. So again, these are some areas that will have to be specifically understood. Next slide, please. Now, cryptocurrency, let's take the example of Bitcoins. So what do you mean by cryptocurrency? Primarily, it's a virtual currency. In simple sense, I'll tell you there are two kinds of tokens. One is called utility token, one is called security token. Utility token is, for example, Law Essentials has can come up with their own. You and I also can coin your own virtual currency. Now, for example, let's say Law Essentials has come up with a virtual currency. Now, what do? They distribute it to all of us who are part of this webinar, and they tell you that, hey, look, this is our virtual currency. Thank you for joining us. Next time, when you have to join any of our courses, all you need to do is you deposit this virtual currency with us. We will give access to your course. So that's something which is called utility. That means there is a utility concept coming in picture here. Now, that's the case of virtual utility token. Now, let's take the example of security tokens. Security tokens is something like your shares and debentures and things like that when you hold it. So what happens when you hold it? They are subject to regulations. When you talk about shares, yes, you have SEBI, you have other compliances and regulations. So they'll have to comply to all of these, and they appreciate and depreciate depending on the stock market. So likewise, you have something called ICOs, just like you have initial public offerings in investment laws. You have the ICO, which are called initial coin offerings. So this is about cryptocurrency. Now, who owns this cryptocurrency? That's going to be one more area that we'll have to look at. Now, what happens if there is an intellectual property? Obviously, when I coin a virtual currency, there's going to be intellectual property. And if I come up with a concept of ownership versus infringement, then there's going to be a very interesting gamut altogether. Now, that's something that you'll have to understand. Second, if I were to protect this cryptocurrency from an intellectual property perspective, how can I protect? Okay, I will take a trademark for the brand name. Okay, but the concept of issuing these tokens, can I go and patent it? Can I patent a particular virtual currency or cryptocurrency? Can I protect my crypto asset, whatever assets I'm acquiring through this cryptocurrency? That's a very interesting question altogether. So this is also something that I thought I should share with you, because now that the latest Supreme Court judgment says that there is a lift of the ban on cryptocurrency, I believe that these cryptocurrencies will be will be catching our attention, and more specifically will be the new kinds of offerings in the near future. So that being so, I think we'll also have to understand that cryptocurrencies and IPR will also be one more interesting area. Next slide, please. Now let's go a bit more further on 3D printing. So there's a new technology that has relatively come up. It's called additive manufacturing or 3D printing. So what's 3D printing? Simple. Now you're looking at the screen. This is a classic example of a 3D printer, 3D printer, and you can create 3D models and 3D objects by way of 3D printing. So what can you do? There is something called CAD, which is computer aided design. You design a particular CAD file, and therefore, once you design it, you can also coin the specifications, the material, the type, the color, the size, everything can be put up. And once you insert the CAD file into the 3D printer, the object comes out. So you're able to see that there's on the screen. That's a classic example of a 3D printed object. Now, what's going to be very interesting is 3D printing is now used in a variety of applications. You also have 3D printed food, to your surprise. So, which is you have 3D printed pizza, you have 3D printed apples that are very popular. Not just that, 3D printing is used in a variety of manners. At 3D printing as a technology, then there's also the medical science that's actually making use of this particular 3D printing for the purpose of implanting medical, what do you say, things. For example, you have some body parts which have been cloned, and 3D printed objects have been made. You have different applications of 3D printing. But all I can tell you is that what can be protected and what cannot be protected. Intellectual property and 3D printing would be a very interesting game altogether. Because the reason is that what can be protected when I talk of 3D printing, the 3D printer as such, the CAD file, because it's ultimately a computer file. When I talk about computer file, again, it becomes a literary work. So it can be protected under copyright. Now, third is the end product. Now, the end product can also be protected by way of copyright and by way of the design, because design, you can also register design under Designs Act, because designs are 3D or 2D objects that are capable of designs or logos or patterns, something like that, what you create. So they also have capability of actually getting protected under intellectual property. So these three are them. And apart from that, if you come up with an invention based on 3D printing, you can also go ahead and actually come up with file a patent. So these are some things that are going to be very interesting. Let's go to the next slide, please. Now, when I talk of 3D printing, there are going to be huge amount of patent-related issues. Why? Because a lot of patented products are replicated through these 3D printed objects. That's going to be very, very difficult and different way to address it. The reason being, the infringement activities under the Patent Act are very, very clear. And if you infringe, you have civil, criminal, and also administrative remedies. So that's something that you will have to understand. And not just that, getting patents for 3D printed objects or 3D printing processes will also be some difficult scenario given the present situation of the Indian patent law. So this is also something. So again, infringement issues versus ownership issues. Again, this is also going to be very interesting when you talk of 3D printing. Next slide, please. when you look at 3D printing and copyright, I feel that there are going to be n number of legalities and n number of legal issues of IPR, specifically copyright with 3D printing. Why? Because just imagine, you can create and you can come up with any design, you can come up with anything and everything using 3D printing. If you print a 3D printed object, what happens to the copyright? That's a very interesting situation altogether. You have infringed upon the copyright by using your 3D printer, then that's going to be an interesting gamut. Who's going to be liable? Again, the question of attribution is going to be playing an important role. Not just that, no wonder that in this context, it's true different matter altogether. Apart from that, somebody breaches the copyright using the 3D printer, then what kind of legal remedies are you going to actually use? Can you actually make use of? You have civil, criminal, administrative. Civil, you can claim for damages. Criminal, you can file a criminal case, and of course the administrative remedies, yeah, police would be seizing the 3D printer and its materials. That's also there, but it's going to open up a Pandora's box of legal issues altogether. Next slide, please. We lost connectivity for 2 minutes. My apologies for it. Yeah, now 3D printing is also being coming up with different issues on trademarks. Why? Because trademark, the logos and brand names can also be replicated using 3D printers. That's going to bring in huge amounts of trademark related issues. We have something called passing off, where you make the deceptive use of a trademark. We have something called so many different trademark infringements that could take place. You can replicate a trademark, you can replicate a logo, you can replicate the brand name using 3D printers. Immense amount of IP issues again. Next slide, please. So likewise, even when I talk about 3D printing and design, it's going to be very different altogether, because designs are also capable of getting replicated through 3D printers. So you can replicate a design which is already protected, and designs also give you a copyright in the design. So it's not just the Designs Act, but it's also the Copyright Act that will be playing a very significant role in this kind of a scenario altogether. Next slide, please. Now let's go on to one of the very interesting domain called Internet of Things. So Internet of Things has been playing a very, what can I say, significant role in each of our digital life. Why? I believe there is nobody today without an IoT device, whether it's your smart TVs, whether it's your smart watches, whether it's any gadgets that has the capability to get connected to the internet, whether it's your smart home solutions, automated home solutions, or whether it's your Fitbits and your health related devices, whether it's your Amazon Alexas or Google Homes of the world, everything. We all consider this to be gospel truth. And in case they're not available to us, we're in a panic mode. Now, think again that when you're trying to make use of these IoT devices, there's a lot of intellectual property that's created. How? Take the example of your medical Fitbits or medical wearables. The moment they are trying to capture your data, there's an intellectual property on the data, because it's ultimately all your health related information. Apart from it being your sensitive personal data, it's also going to create a lot of intellectual property out of your data. Now, who owns this? Have you ever thought of it? That's $1 million question. Well, I don't mean to cause any kind of issues to the wearable devices and their manufacturers, but just like to tell you that be cautious, because think about the intellectual property that's generated out of this particular devices. Who owns it? And in case there's a breach or an infringement of this IPR issues with regard to the IoT devices, who's legally held responsible? Is it you, or is it the manufacturer, or is it the reseller? Who's going to be legally responsible? That's going to be an interesting question as we discuss forward, because IPR is going to be copyright infringement, because huge amount of data. When I talk about these Internet of Things devices, whether it's Amazon Alexas and the Google Homes, they would be actually trying to give you a lot of content. For example, let's say that the content, some content is actually copyrighted material, but it hosted on these for a specific purpose. Let's say I make use of it and I try to make commercial use of it. Am I violating the intellectual property? In that case, who would be legally held responsible? Me, device, or the seller, or the manufacturer? That's going to be an interesting question that will pop up altogether. So I believe that these are some things that these are some snapshots of the IPR related legal issues, and there are more over the horizon. And while we are all seeking answers to this, I think webinars and sessions like this are going to be good deliberations that are going to engulf and that will propel us to come up with some thought process when I talk about intellectual property and emerging technologies. So I believe that we should re-innovate ourselves, and more specifically that we cannot be in the 20th century and have 20th century mind to tackle the issues of 21st century. I think without dirtying our hands, I believe that intellectual property rights have to be protected. While at the same time, we should also inculcate the habit of actually trying to understand how intellectual property is catching our attention when we try to make use of these emerging technologies. Next slide, please. So even wearable technologies is what I was just trying to tell you, whether it's the Google Glass, or whether it's your wearables, whether it's your smartwatches, whether it's your apps. I think they're going to be posing immense amount of intellectual property related issues, not just with regard to ownership, but also with regard to infringement activities. These are some things that we'll have to clearly understand. And not just that, I would start encouraging you to actually read the terms and conditions so as to understand with whom all these data is being shared and how is this data used, so as to get more clarity on uh, the aspects of intellectual property protection and things like that. Because I believe these emerging technologies have changed our lives dramatically, and not just that, they're going to completely uh, do away with the concept of intellectual property protection, and they're doing a lot of covert and overt activities with the intellectual property that is arising out of the use of these emerging technologies. Next slide, please. So I believe in a session like this, what is necessary is only what is required. So I thought I should just take you through some of the areas of emerging technologies and the intellectual property rights. And I believe that this session is a reflection of how the intellectual property jurisprudence is evolving with the emergence of our technology. The Western centric approach has a different paradigm altogether, but I can tell you that while our conduct don't think that your conduct with the emerging technologies has got unnoticed. No wonder that all of these emerging technology leaders are doing a lot of activities in trying to protect the intellectual property arising out of these use of these technologies. I think while we are enjoying the emerging technologies, we also need to understand the dark of these technologies underbelly, which would basically not expose us to any kinds of intellectual property breaches and contributions, either directly or indirectly or in whatsoever manner. I believe that while we are all trying to be smart using these smart devices, we also have to be equally equipped with regard to understanding the intellectual property rights with regard to these emerging technologies. So that's all I have got from my side. Once again, thank Law Essentials for this wonderful opportunity, as also Farhan for this wonderful opportunity for coming up with this talk altogether. And if there are any questions, I would love to take them up. I'm open to questions.
Surely, so thank you so much for that intriguing session. Many of us, I think, will be able to brainstorm over what you actually spoke and bring in a deeper thought process to come out with maybe different ideas as well. We have a question coming in from the audience. Our smartphone is
Yes.
also a part of AI. If the owner of the company updates a new software for our smartphone, should that be copyrighted?
Wow, it's a wonderful option that question that's been raised. I believe definitely. See, the software that's been updated definitely would be protected under copyright specifically. But if it is a freeware, if it is an open source, then IP protection may not be relatively available. So I believe it's all depending on the kind of software being used by the phone manufacturer as such. But however, it's still a very good point, because if it's copyrighted, I believe it's not just the software, but it's also the data that's available on this particular device that will be copyrighted by them. That's something that we all have to increasingly understand. Thank you for the wonderful question.
Thank you so much, sir. That was a really inspiring answer. With this, we come to the end of the session. I would really like to express my deepest gratitude for you for joining in this session and extending your support to our organization in all ways. It was a wonderful session, and the audience have loved you throughout the course of the session.
Thank you so much. I think with each passing day, each passing month and year, I believe that new waves of laws and legal jurisprudence will evolve as time passes by. And more specifically, I am of the opinion that once we get victorious over COVID-19, we are all in the stage of voyage and transformation. And I believe once we get victorious over COVID-19, there's going to be a new cyber world order that's going likely to emerge. And that will bring about answers to all of these issues that we have discussed in this session today. So thank you so much. It's been a pleasure talking to all of you this evening.
Thank you so much, sir. With this, we come to the end of the session. Thank you so much, all the audience, for attending this session.